So today I will start with the first case laws. Now I'll ask one question because many friends have switched on their videos. So I hope they will also participate in the discussion. Thank you, Sumanji. My question is, can anybody say what is privity? What is privity of contract? Because I am going to read the case laws with reference to privity, and where many IPs or liquidator have committed mistake in executing the CRP work or liquidation work. So we should learn the lesson from the other's mistake. This is the concept of wise person instead of committing first mistake. Yeah, Shekhar Agarwal ji, please.
Privity of contract means the contract is between two parties, and those who are not parties to the contract has no rights or obligation in that contract.
Correct. Thank you, Shekhar ji. Privity is of contract means the parties to the contract. Parties to the contract, whose consent has been given, whose right has been affected due to consent, and they are parties to the contract. I will share this definition in screen also, and then we'll refer the case laws. Just a moment. Share the screen. You are sharing the screen. Just a moment. First, I will read, just a moment. I will read the section 10. Section 10 of the Contract Act. Just a moment. And then I will read this Section 10 of the Contract Act. See, if we understand the basic or fundamental aspects of the contract, we will not ask many questions during CRP from the other person or from the legal counsel. If we understand the basic concept of the contract laws. Number one, Section 10. What is agreement or contract? Everybody knows. Still, I am reading only one line. All agreements are contract if they are made by the free consent of the parties competent to the contract. That's it. I will not read other lines. Now come to consent. Consent, the word consent is very important here. Section 13 of the Indian Contract Act says consent means two or more persons are said to consent when they agree upon the same things in the same sense. Agree upon the same things in the same sense. So this is the consent. Now come to privity. The doctrine of privity of contract is one of the major principles that govern the law of contract. Why I have covered this topic? Because this is going to affect the other things also. Now, the word privity means with the knowledge and consent. According to this doctrine, only parties to a contract have the right to enforce the right and obligation provided by the contract, and stranger to the contract are barred from enforcing any obligation on any party. This doctrine protects parties to a contract from obligations that they never agreed to incur. Only those parties that have an interest in the contract can sue for its enforcement. The first case in India, this is the case law. I am not going to read this one. Just we will understand by the example. For example, and B enter into a contract where A gave ₹100 in return, for which B agreed to deliver a watch to C. B has agreed to deliver a watch to C against the consideration of ₹100. Contract between A and B. Now, B fails. Here, since C is stranger to the contract, he cannot sue B. Is this clear? Why I am reading this?
Clear, sir.
Yeah. Why I am reading this thing? Because I have come across some cases where 4 years, 3 years CRP was going on, resolution plan was passed, and ultimately the resolution plan was disapproved by the enclave. The entire process of 3.5 years or 3 years went into vain. Now come to relevant case laws to these provisions. Even in CRP, you will find many things like contract, like agreement, this guarantee contract, personal guarantee contract, like that. Now I am coming to first case is Noida. Noida Authority, Greater Noida Authority versus Roma Unicorn. This is the recent judgment. 2023, it has been passed by the enclave. Here, what happened? Earth Infrastructure Limited, Roma Unicorn, Earth Town Plan SDFC Monitoring Committee. These are the parties to the respondents. Here, let me brief you first, then I will share this screen. What happened? Land owing company is here, land owing company is Unicorn, and CD is Earth Infrastructure. See this, please do not think that this apply to the only real estate company. This will apply to other companies also where these assets are there, immobile or movable. That's why I am covering this case. Land owing company is somebody else. CD, corporate debtor, is Earth Infrastructure. Development rights, development agreement entered between these two companies, and thereafter this company CD, Earth Infrastructure, went into CRP in June 2018. In June 2018, it has gone, it went into CRP, and thereafter this resolution plan, EOI invited, resolution plan came, and resolution plan approved. In that resolution plan, it was mentioned that the land will be transferred to the SRA. Successful resolution applicant, because resolution plan was approved by more than required percentage. What happened? In that, when this resolution plan was passed, Noida Authority was not part of the meeting because he was operational caterer. He has filed their claim before the RP, but land belongs to Greater Noida Authority. Land belongs to somebody else. Greater Noida Authority is the lesser. Lessee is somebody else. CD is the approving, CD is in CRP and approved the resolution plan of the SRA that yes, this land will be transferred to the SRA. Now I'll share this screen. I'm just discussing on bullet points instead covering all aspects. This was the section 7. Roma Unicorn. Roma Unicorn was the SRA. The respondent has submitted proposal is against the terms. The resolution plan. The resolution plan was filed by the RP, whereby the resolution plan was approved by AA, and Roma Unicorn was the SRA. Now come to relevant para. There was a default in payment of lease rent of the land. Dues was huge. 148 crores were the dues to the Greater Noida. Now come to the land owing company. The lease deed was executed in favor of the Earth Town. Land owing company is the Earth Town. CD is the Earth Infrastructure. The SRA proposed that land should be transferred in their favor. resolution plan was passed with the required majority. A also passed the order in favor of the SRA. Then Noida authority approached before NCLAT and raised the objection that how this resolution plan can be approved without the consent of the lessor. Now come to relevant portion of this. Page 105. Just a moment. We'll come to. Yes. NCLAT found that there is a violation of law because without the consent of the Noida authority, how this land can be transferred. So NCLAT has taken the holistic view here. The facts which have been brought on record indicates that the hundreds of crores have been received from the allottees, and allottees are waiting for last several years to receive the possession of the flats, so and so and so and so. Now we have to find out the ways and means to protect the interest of the allottees, which is paramount importance. See, here the enclave has taken the holistic view and goes beyond the law. That otherwise the resolution plan itself is void ab initio. But it has taken the holistic view in order to protect the interest of the home buyers. We have also heard that without approval of the appellant, here noted, subject land could not have been transferred in favor of the SRA or resolution applicant or any other entities. It is obvious that appellant, before granting any permission or for transfer of the land, shall require their dues pertaining to the land premium, lease rent and other legal dues to be cleared. We may also notice during the submission letter. Now come to, then thereafter what happened? Enclave issued direction or pass the order. RP has to publish a fresh Form G. Now come to, now see, after when it started the June 2018, 2018, this CRP started. In 2023, this order passed. Now RP will publish Form G again. It is again going back to fresh start of CIRP. And it will invite resolution plans from the other applicants or other bidders. So this is the order. I'll also tell you the similar things happen in one more case. I will not tell the name because of this privilege between the client and the advocate. I will not share the name, but similar mistake has been committed by another this CRP proceeding, where the land owing company is different company and CD approved the resolution plan. RP got the approval and filed the application, and this is still pending. So I hope the same analogy will be applied here. So we have understood the privity of the contract. Without privity, agreement is void. Okay. Now come to, I will take another case. This is a very hot case, which we have discussed 2 days back. In fact, yesterday itself. Regent Power Take. Order passed by the Honorable Supreme Court. What RP did mistake, he committed one very big mistake, that the resolution plan or something associated with the stakeholders was disapproved by the enclave NCLT, and then he went to Supreme Court. So here Supreme Court says the resolution professional is the independent body, independent entity. He should not file any appeal against the order of NCLT or enclave. Here the aggrieved person RP is not the agreed person. RP is supposed to manage the CIRP or liquidation process of the CD only. If there is some personal this problem.
Sir, you are not audible.
Pardon?
You are not audible.
Just a moment.
He is audible.
Okay, I think there might be some
It's not his end.
audio problem at your side. And
You are
Now
audible.
it's fine.
so,
Then, sir.
Now it's fine.
see, okay, thank you. Law is very much clear. Nobody can be deprived from the legal remedy, legal rights. Here, RP is not the agreed person. Agreed person is the COC or other stakeholders. They should have approached Supreme Court or enclave. Whereas here, RP has filed an appeal, which has been turned down by the Supreme Court, Honorable Supreme. We are of the opinion that in view of the facts and circumstances, the resolution professional should not have filed the present appeal. The resolution professional should have maintained the neutral stand. It is for the aggrieved parties, including the COC of Regen Powertech and Regen Infrastructure and Services Private Limited, to take appropriate proceedings or file an appeal before this court. Recording of the aforesaid, the present appeal preferred by the resolution profession are dismissed as not entertained. If required and necessary, the court can take assistance and ascertain the facts from the resolution professional in case an appeal is preferred by committee of creditors or third parties. Here what happened? The news was circulated by the media people that RP cannot file any appeal before adjudicating authority or enclave, which is wrong. Agreed person can file. If adjudicating authority pass any personal remarks or give any adverse observation in the order where rights of the RP gets affected, RP can always file appeal before enclave. Is this clear? Now I'll take another case. This is little bit old case, but this still applies because 2 days back, one association of employees approached me for their grievance for their salaries. What happened? That employees approached me that they have not received their salaries or dues pertaining to CIRP period. If work has been performed by the employees or workmen during the CIRP period, it will be part of the CIRP cost. It is very much clear. It is settled law. But RP did not pay the salary or wages of the employees. The leader of the employees and workmen approached me. What is the remedy? I will tell you subsequently. First, I will share the case law. See, these type of problems will come everywhere. Kumar, Jain and others, Honorable Supreme Court, Sundaresh Bhatt and others. Here, ABG shipyard was in liquidation and some employees or workmen worked with the CD. During the CIRP period, they filed their claim before the RP or IRP pertaining to prior to CIRP period and post CIRP period also. So prior to CIRP period becomes claim, post CIRP becomes the CIRP cost. However, this liquidator who was earlier RP failed to pay their dues and taken the ground that company was not going concerned and he is unable to pay the wages or salaries. Now come to just a moment. ABG shipyard, the relevant para is last. We have heard the learned counsel for the respective parties at length. The issue before this court is with respect to wages, salaries of the workmen or employees during the CIRP period and amounts dues and payable to the respective workmen towards so and so. While considering the aforesaid claim legislative, these are the pension and sorry, what this PF, that is 100% allowed. Now come to salary part. Sorry. Now come to salary part. Yes. In view of the above and the reason stated above, it is held as under that wages oblique salaries of the workmen oblique employees of the CD for a period during CRP can be included in CRP cost, provided it is established and proved that the IRP or RP managed the operation of the CD as a going concern during the CRP, and that concerned workmen oblique employees of the CD actually worked during the CRP, and in such an eventuality, the wages oblique salaries of those workmen oblique employees who actually worked during the CRP period when the resolution professional managed the operation of the CD as a going concern shall be paid, treating it and considering as part of the CRP cost, and the same shall be payable in full first as per section so and so. So here the question came before the Supreme Court that whether the CD was going concern or not, whether RP managed the CD as a going concern. Here the liquidator took the stand that CD was not going concern. But now come to last para. There are disputed question whether in fact RP managed the CD as a going concern, and there is serious dispute whether Dahej yard was in operation during the CRP or not. There is a serious dispute that the concerned workmen or employees or employees of the Dahej yard and concerned employees of the Mumbai office actually worked during the CRP or not. Therefore, it is directed that let the appellant submit their claim before the liquidator is established and prove that this during CRP or RP managed the CD as a going concern, and that they actually worked during the CRP, and the liquidator is directed to adjudicate such claims in accordance with the law and on its merits and on the basis of evidence which may be led or produced irrespective of the facts whether the RP who himself is now liquidator includes the claim so and so and so and so. So it has been referred again matter to liquidator and the agreed person. Agreed person is the workman and employees, that he has to prove that the CD was a going concern. Then he is entitled to get all salaries, wages pertaining to CRP period as a CRP cost. Now, in one of the case for which I have discussed that the agreed employee approached me just 2 days back that he has not received the salaries or wages, and the IP has taken the same stand of ABGR. Now this case is different. Here, in my client's case, I will not disclose the name. In my client case, the resolution plan was approved. See, where RP has committed mistake, resolution plan was approved. There were 20 employees who were working with the CD during CRP period. Out of 20s, 10 gets payment of CRP, this wages and salaries. Remaining 10 employees have not received. They filed their claim, they filed application before RP for releasing of payment. They said the company was not going concern, so I cannot pay. For remaining 10 employees, he paid because he has taken the stand that they actually worked during the CRP period. See, here the discrimination has been committed by the RP that 10:10. He has paid for the 10. For 10, he has refused and taken the stand that the company was not going concern. This is wrong stand. And COC has also disapproved the salaries of 10 employees. Okay, COC has right to approve or disapprove the CRP cost. Here, there is a lacking from the RP side that if COC has disapproved this claim or CRP cost of the employees, then RP should have moved an application before AA. So put up before the AA, then my lord, kindly look, this is the CRP cost. This has been disapproved by the COC. So this is before you for approval. So definitely A must have approved, because here resolution plan was also approved and resolution applicants should have paid this money. So there is a gap between the execution and the entertaining the claims. Now I will again take another practical aspect. So this is the lesson which we can learn from the others' mistake. I told you initially that wise person is a person who learned the lesson from the others' mistake. Now I'll take another case. I'll ask one question. Suppose, see, RP or IRP has to finish the CRP work within 180 days. RP or IRP has to finish the CRP within 180 days. RP put up this resolution before the COC for extension of CRP period on, say, last day or one day before the last day of 188 days. 180 days. Say 30th September is the last date of CRP. He put up before the COC on 29th September or 30th September. Kindly pass the resolution for extension of CRP. COC passed the resolution for extension of CRP. Then RP moved an application before AA. What will be the fate of this application? Because he has moved this application before AA after 180 days. Can anybody answer?
Technically, it should be rejected.
Okay.
Reason being,
Niranjan ji.
extension means something which is already going on can be extended. Something which has already come to an end cannot
Okay.
be extended. So technically, it can be rejected, but then practically the extensions are given and periods get
Okay.
excluded.
Okay, okay. Anybody else can also participate? Whether A should reject or accept? I think everybody has finished their lunch and now I will awake you by raising such type of questions. Okay. This case first time came before me. I'll share the case law also. This is a landmark judgment which is still following. Just a moment. The case came before me and I filed an application before NCLT Mumbai. It is this pertaining to 2017. I filed this application before NCLT Mumbai. My client approached me for filing of this application for extension of CRP period. Here, on the application moved by the RP seeking extension of CRP period for another 90 days as envisaged under section so, when this bench has looked into the application, it has been noticed that this application has been filed on 30th November 17 on a resolution dated 24th November 17, passed by the COC seeking extension of time. By the time this application was moved by the RP, 180 days of CRP was completed by 25th November 2017. So Mr. Sekhar was telling, and the same analogy was adopted by the AA of Mumbai. On visiting of these provisions, we have noticed that the application shall be filed by the recent professional for extension of CRP before the completion of CRP period. So since there is no provision of revival of CRP period to provide another 90 days extension as mentioned under section 12 subsection 2, especially when earlier 180 days period is completed by the time application has been filed by A, we strongly believe that it will become nothing but exercise of jurisdiction beyond the power conferred under this bench under section 12. Since it is a tribunal created by so and ultimately this application was rejected. Now I filed an appeal. Now come to appeal part. Quantum Limited. This judgment is still following in many judgments. I have noticed recently also. Quantum Limited. This application under sense of the allegation that the application received certified. This is the certified copy of. Just a moment. Next to. Let notice be issued. Just a moment. Now come to final judgment. Sorry. First, we should understand the provisions of section 12.2. What 12.2 says. I put up before the enclave this argument 12 subsection 2. 12 subsection 2. Time limit for completion of insolvency resolution process. First is 180 days. Subsection 2 says the resolution professional shall file an application to the adjudicating authority to extend the period of CIRP beyond 180 days if instructed to do so by the resolution passed by the meeting of the COC by a vote of 66% of the voting share. Here, law says, code says that if resolution passed by the COC, this subsection doesn't say that it must have been passed. It must have been passed. Sorry, it should be passed. It is silent about the time of the passing of the resolution. It is silent about the passing of the resolution. So I have taken the same stand. The resolution plan, so resolution was passed by the COC prior to completion of the CRP period. Although we have filed application for extension of CRP after completion of CRP period, which is not barred under section 12. So I have taken the same argument before the enclave, and Justice Mukhopadhyay was there that time. The time limit for completion, he has reproduced this provision. It is clear resolution plan can file the application. Only the instructors who resolution plan 25%. In the present case, adjudicating authority has not hold that the subject matter of the case do not justify to extend the period. It has not been rejected on the ground that committee of creditors or resolution professional has not justified their performance during 180 days. In such circumstances, it was duty on the part of the adjudicating authority to extend the time to find out whether a suitable resolution plan is to be approved instead of going for liquidation, which is the last recourse on failure of the resolution process. Just a moment. For the aforesaid reasons, we set aside the impugned order dated so-and-so of AA and extend the period of resolution process for another 90 days to be counted from today. The period between 181 days and passing of the order shall not be counted for any purpose and is to be excluded for all purpose. Now the adjudicating authority will proceed in accordance with the law. The appeal is allowed. So this judgment.
Jain, can I comment for a moment here?
Yeah, please.
There is a section 166 under Companies Act 1956, and there is a similar section 96 under CA 2013. There are many cases where the extension is applied before ROC beyond that 6-month period. That's standard. People do apply it. The cases have gone up to Supreme Court. The Supreme Court has very categorically held that extension can only be given in cases where the application for the extension is made before the time of holding an event has come to an end. When the time has stopped running, the ROC does not have any power to extend the period of holding a year. I think similar analogy should also apply here. Congratulations that you got through this favorable order, but if it is challenged before Supreme Court, I'm afraid it may not hold the ground.
Thank you, Manishji, for sharing your experience. I'll tell you here, you are telling about the ROC matter when the company is not in CRP. Here, company is in CRP. The approving authority, the main approving authority is COC here. COC has approved the extension period by 75% of voting rights. Earlier, it was 75% before completion of CRP.
Anyway, let's not get into it.
So
We can
same
continue.
analogy was applied during the argument, and Honorable Anclate accepted this argument and passed this order. Thank you.
Sir, may I say something? I'm Jay
Yes,
Gopal
please.
Venkatraman.
Yeah, please.
A resolution professional. See, you
Yes.
narrated one experience. I also had a similar experience in Bengaluru NCLT bench,
Okay.
where the NCLT advised that you have to, no, for the liquidation period, the COC assembled after the completion of 180 days, and sorry, after 180 plus 90 days, 276 days, and applied for liquidation. That means the resolution was passed in favor of liquidation. So at the time, I was suggested by the Honorable NCLT that ensure that when you apply for this one, the IA, when it is filed for liquidation, ensure that the condonement of delay also for filing, conducting the COC meeting after that 273, because there is a little problem in assembling the COC members. There is a gap of 2-3 days delay.
Very well, very well. Thank you, Jay Gopalji, sharing for your experience. Recently, I filed one appeal, and that appeal was rejected on the same footing that what happened. It was Section 9 application moved before an NCLT by some other council, and the application was rejected by the dismissed on non-prosecution, because advocate did not appear on the date of hearing, and non-prosecution, the application was rejected. Thereafter, another counsel engaged by the client, and he moved an application for restoration under NCLT Rule 148. Okay. And that application was moved after 150 days, whereas the time limit is given 30 days. That for restoration of application, party should move to NCLT within 30 days under NCLT Rule 148 sub rule 2. Okay. So again, this application was rejected by the NCLT on the ground that you have not filed any condonation of delay application. So there is a gap. There is a lacking from the counsel or from the client.
Had they added this word, it would have been prayer. The prayer would have contained.
And then this file came to me, and then he said, you approach this enclave and to file appeal. I said, we have only 50-50 chances. I cannot say, because the big gap between this order and this application is that there is a lacking of condonation of delay application. So if condonation of delay application would have been there, then in the interest of justice, this application would have been allowed. So NCLT has dismissed my appeal also. Yes, and taken the same view that you have not complied with the legal procedure. If there is a gap, you should accept this gap and accept the gap and file a condonation of delay application.
Very interesting.
So this is, that's why I told we should learn the lesson from the others' mistake instead of making mistake and then learn the lesson. So this is not the wise person. So this is not the wiser things. So now come to thank you.
Thank you.
So, may I come in here?
Yeah.
See, when you look at what happened in company law, with what happens in NCLT, IBC, under IBC, I think the difference here is that the NCLAT must have rightly held that the company should not be pushed into liquidation. If the extension is not allowed, then company could be pushed into liquidation. So that could be one reason why they would have allowed.
May I request Naveen ji, can you repeat? Actually, my attention diverted.
No, it's not a query. It's with reference to what we were discussing just now. Like someone pointed out that the Supreme Court has held that under company law, if the application is not made.
Yes, I got your point.
Yeah.
I got.
So the difference here is that
the concept is the going concern. Instead of pushing the company into liquidation,
absolutely.
The first and top priority is paramount is going concern. Yes.
Just
agreed.
Because there is a procedural lapse, the company should not be pushed into liquidation.
Yes,
so that is the overriding.
Yes. Thank you. Thank you. Now I'll take another case. I'll just discuss practical aspects. I think you are paying your attention in case laws and this practical experience also. Just now my question is, I put one question before you. Company has gone into CRP, say from 1st October of this month. IRP has taken the control of the company. There are 3 directors. One director is the signatory of the checks, and he is executive director in working in the company. He is getting salary also. Now, my question before you, can he sign the check? Can he issue the check to the vendors? After commencement of CIRP, can he issue the check? He is a executive director, company is a going concern, factory is running. Just a moment.
I think he can do it, provided the RP has authorized him to do that. If the RP authorizes him to make payments to the vendors.
You said yes, the executive director can issue the check, you said.
Yes, if authorized by the RP or IRP.
Yeah, you are right. I'll share the case law also in
Well-
support of your statement. Just a moment. Just a moment. Enclate has passed. There is some problem in sharing the screen. Refresh. Participant can now. You are. Can you see my screen? There is problem in sharing the screen. You are screen sharing. Just
You can see the screen, but
okay, there is some problem in technical problem. Just a moment. Let me again try. You can't open this file. Something wrong. Okay, there is some problem in the file itself.
I
Okay,
think you're trying to open through
yeah, there is some technical problem in file
Uh,
itself. So I'll just share. I'll
open
just
with
share.
open with Adobe. I think it will work.
I'll just say. I'll just share the outcome of this judgment in Enclate. Enclate says that company is a going concern. Power of the director has been suspended. He has not been terminated. He is still working. His only power has been suspended. His duties still lies. His responsibility still lies. He can work anything for the company under the approval or under the permission of RP or IRP. So check issued by the director is valid because he has issued the check with the permission of the IRP. Okay, so this was the outcome of the judgment. This was not opening due to, I think, technical problem. Now I'll share the another problem, another practical aspect, shifting of plant. Just a moment. Yes. Here what happened? The corporate debtor wanted to shift their plant from Pune to Bahadurgarh, here, Haryana. And while passing this resolution by the COC, this workmen got stay from the industrial tribunal in Pune. So I filed an application on behalf of the RP and before NCLT Delhi. What happened here in Garg Agnos? The petition in the just a moment. I'll read the only relevant paras. Here, para number 5. The moratorium imposed by this bench mandates a stay on all proceedings before the other courts. Though the learned code means industrial tribunal code, labor code, who has granted stay from shifting of this factory from Pune to Bahadurgarh. So here the para says the moratorium imposed by this bench mandates a stay on all proceedings before other courts, though the learned code has taken note of the provisions of section 63, 64 of IBC and has fixed the matter for maintainability having been filed during the period of moratorium. The interim order is directed to continue for a period of 15 days to enable the complaint impugn the same. The submission of the financial creditor as well as applicant Sri Sanjay Gupta RP that a further delay of 15 days is extremely crucial considering the revival or resolution plan has been worked out within 180 days merits. Considering accordingly the impugned order which has been passed in the face of moratorium needs to be set aside. We are in respectful disagreement with the direction of the learned industrial code. In our considered opinion, no interim order could be passed, much less extended. The resolution professional is directed to take expeditious step for taking steps as approved by the COC. Given the facts and circumstances of the case, we direct the RP to take necessary steps for shifting of plant and machinery to Bahadurgarh, Haryana, and make endeavor to keep the corporate CD as a going concern. So this has been allowed, keeping in view, and one rider has been put that the interest of the workmen should be protected. That's it. So if other court grant stay, so what RP should do? RP should move adjudicating authority for vacating the stay because of moratorium. Now come to another case. Just a moment. ABC, we have already checked. Now, I'll put first question before you. Check issued. See, such questions or such problem must have come before you also. Check issued prior to commencement of CIRP. Kindly listen carefully. Check issued prior to commencement of CIRP, say 1 week or 10 days. And this check got encashed after the CIRP. 1 week or 5 days or 10 days. Whether is this violation of the moratorium? Check issued prior to CIRP, say 1 week, encashed after 1 week of the commencement of CIRP. Yes,
Yes, sir.
Vijay.
Yes, sir. This is violation of moratorium.
Okay.
No, sir, it is not violation.
Pardon?
It is not a violation because it has been issued.
Okay. So there are different opinion. One is of Mr. Mukesh Gupta and Abhi Narayana ji. Okay. I'll share the order. Here the head note given by the Institute of ICSIP. The payment of check released subsequently relates to back to the receipt. Just a moment. Size का बढ़ाने का. The payment of the check released subsequently relates to back to the receipt of the check, which is in the instant case appears 8th January. And since the moratorium was declared 12th January, check was issued on 8th January 2022 and moratorium was declared on 12th January. This transaction in view of the ratio of the Ogale glass works does not violate the moratorium. Therefore, in our considered opinion, this transaction cannot be termed as preferential or violative to moratorium and accordingly is rejected. IA number so rejected. Just a moment. Here one more this reasoning has been given in the case of CIT versus Ogale glass. it was laid down, but this quote that payment by check released subsequently on the check being honored and encashed relates to back to the date of receipt of the check, and in law the date of payment is the date of delivery of the check. Payment by check is an ordinary incident of present day life, whether commercial or private, and unless it is specifically mentioned that payment must be in cash, there is no reason why payment by check should not be taken to be due payment if the check is subsequently encashed in the ordinary course of business. So in ordinary course of business, the check was issued, encashed subsequently. So this is not the violation of the moratorium. This view has been taken, this order has been passed by the NCLT Kolkata. Now I'll take the thing.
Sir, one small doubt, sir.
Yeah, please.
Sir, ideally, the ERP must have taken the in charge of the CD on the insolvency commencement date. Ideally, will not do. But ideally, supposed to say he has taken the in charge of the CD and has inputted his signature. That means signatory change also was conducted in the bank. Supposed to say, what about the fate of the checks that are issued prior to ICD and coming back after the ICD? Because bank will reject them in toto because the signatory having not been matched.
So in that
Ideal.
case, ideally, what IRP should do, the moment he comes to know that the CRP has been commenced, he should immediately first shoot letter to the bank to stop all payment,
Yes,
to
sir.
stop all payments.
Yes, sir.
Because
Yes, sir.
with the along with the order by email, by hand copy, hard copy, whatsoever mode, or by telephone also. But practically it doesn't happen. Why? Because order is uploaded after 2-3 days. IRP
Yes, sir.
received the order after 2-3 days. The moment he received the order, some checks also got encashed. So this is the
Yes, sir.
practical problem. So in that case, the same analogy will apply. But here, IP should not take any risk. He should file an application before adjudicating authority for reversal of the transaction. Whether adjudicating authority accept or reject doesn't matter. But at least you should save your hands.
Yes, sir. In one of my case, I have requested the beneficiary of the check. It's a small amount. He has returned the amount.
Okay.
After the CRP period, he has encashed. So I requested him to return because it is not yours. It is a violation of moratorium. You please return this funds and to the account of the CD. He has returned.
It's good you have you received the return. Otherwise, because because many these businessmen don't want to litigate the matter.
Okay. Thank you.
Now, (10A). Now I'll again take another matter of this section 10A. Just a moment. Section 10A. Here, first I will explain the case. What happened here? The lenders is secured by the corporate guarantee. Lender is secured by the corporate guarantee. He has given loan to the corporate debtor. Lender issued notice invoking the corporate guarantee. Lenders has given loan to third party, but corporate guarantor is different because guarantor is always different person. There are 3 parties in one guarantee matter. So lender has issued notice to the directors of the corporate debtor. In 2019, August 2019, lender issued a notice for invocation of the corporate guarantee addressed to the directors in August 2018-19. Thereafter, he realized that, but he didn't receive any response or they refused to respond. Thereafter, he realized that he has done some mistake. Then he issued another notice in August 2020, invoking the corporate guarantee in the name of CD. So what will be the fate of this invocation? Can anybody say? Yes, Vijay ji. Niranjan ji. The guarantee invoked, corporate guarantee invoked in August 2020. I'll say, let me clarify. The corporate guarantee, sorry, the lender issued first letter to the directors. He said, please repay my this loan. Otherwise, I will execute this thing, the guarantee papers. He didn't receive any reply. Thereafter, he sent another notice in August 2020. And then the application, this was also turned down or rejected by the adjudicating authority. I'll share the judgment. What happened here? The earlier letter dated 16/11/6/2019 was addressed to Mr. Hemendra Aran and Gitanjali Sinha in their personal names as a director. However, both the persons were not directors of Aranka Mumbai Private Limited on the said date, and this letter cannot be treated as invocation of the deed of guarantee. Further, in the formal notice for invocation of deed of guarantee dated 25th August 2020, the appellant has not even referred to this letter before part and so and so. Since the deed of guarantee was invoked on 25th August 2020, CRP cannot be initiated for default in repayment as a default arises in the period excluded by the provisions of section 10A of IBC. The AA has rightly held that default falls within the specified period 10A, that is the cooling period, where CRP cannot be initiated due to COVID period. Again, same analogy will apply. I said first at the beginning of this session, privity is very important. Here, see, again, this lender has committed mistake. He has issued notice to whom? Directors, instead issuing notice to CD. So here privity is lacking. His letter went into when? First letter. And then when he realized that he has committed the mistake, and then subsequent letter was barred by the section 10A due to COVID period. Now come to another judgment. This is the case was already pending before the DRT under the provisions of SURFACI. Under the provisions of SURFACI, this is the recent judgment of NCLAT Delhi. The case was already pending before the DRT. Settlement took place between the parties. Thereafter, insofar as the submission of the appellant that bank has approached the multiple forums, including the DRT, is concerned, it is well settled that litigation in SURFACI and DRT does not preclude the bank to take specific remedy provided under section 7. Hence, the said submission does not help the appellant. So he has taken the stand, appellant, that the matter has been settled and the matter has been pending before the SURFACI. This will not help the appellant because this is the independent jurisdiction and it is the independent proceedings. It has nothing to do with the DRT proceedings. we have to prove, as an applicant, we have to prove there is a debt and there is a default. That's it. Nothing more, nothing less. Once we prove that there is a debt, there is a default, section 7 will rise or section 9. Now come to now, first of all, I put one question before you, whether NCLT or NCLT can recall its order if subsequently NCLT or NCLT finds that there is some error in the order or there is some mistake, the order has been passed due to some mistake or mistake of facts, can NCLT or NCLT recall its order?
Yes, we can, yes, sir. We can recall, sir.
Okay. Anybody else?
Yeah, they can recall.
Okay, thank you. Yes, the same judgment was passed by the just a moment. In the matter of SVA Family Welfare Trust versus Ujas Energy Limited. Would not have been contained a provisions of extinguishing a oh, this is different. This is different. I'm sorry. Actually, this order was passed by the adjudicating authority approving the resolution plan, whereby adjudicating authority this resolution plan extinguishes the right of the lenders, which is not allowed. Resolution plan cannot extinguish the right of the lenders with respect to the personal guarantee. So here NCLT held that the adjudicating authority committed error in rejecting the application for approval of resolution plan on the ground that plan could not have contained a provisions for extinguishment of personal guarantee of the personal guarantors. Plan allocates a plan value of extinguishment of personal guarantee, which has been accepted by the financial creditor by vote of 78.04%. The order of the AA dated 6/1/2023 is unsustainable. In the result, we allow the appeal and set aside the order dated 6/1/2023 passed by the AA. The resolution plan submitted by AA did not contravene any of the provisions of section 30 subsection 2E of the code. The AA shall proceed to pass the fresh order under IA 190 of 2021, praying for approval of resolution plan along with the necessary direction. A shall endeavor to pass fresh order so and so, so and so. So here, what A committed the mistake that A allowed the extinguishment of the right of the third party, which is not permissible. So again, the concept of privity will apply. First, that's why we read first section 10 of the Contract Act. Thereafter, we read section 13 of the Contract Act. So there is no privity. Nobody can take away the right of the third party.
Excuse me.
Yeah.
I happen to be the RP of this company, Ujas Energy Limited.
Okay.
Right. Hello. Can you
Yeah.
hear me?
Yes, yes, please, Naveen.
Hello?
Tell me. Yes,
Yeah.
I am hearing. Please tell me.
Yes. Yeah. So in this case, the matter has gone to Supreme Court now. But what NCLT said was exactly the opposite of what NCLT ruled. You know, the NCLT said that the rights of the personal guarantors can be extinguished. This is what they have ruled. Of course, it is now being challenged before the Supreme Court.
There might be some divergent judgment, but the contract of guarantee is between the bank and the guarantor. Bank and the
Yes.
guarantor. So CD or the resolution applicant cannot extinguish that right. This is violative to the contract law.
Yeah, this is the general belief, but in this particular case, which is now being held as a landmark judgment, they've said that if the
This,
majority
I
of
think
the
this
financial
matter is
creditors,
pending. Whatever you are telling, please, can you tell me the case, name of the case?
Ujas Energy Limited,
Ujas
is this the
Energy.
one?
Just a moment. I'll jot down. Energy Limited. Okay. So this matter is pending before Supreme Court.
Yes, now it has gone to Supreme Court.
Okay. So let's see what Supreme Court decide. Thank you. Now come to another case. Police. Now FIR was registered against the RP. Here you might have heard about this case. NCLT Delhi passed this order. See this order. This is very important for RP. If RP get harassed by the police or somebody else, the present application has been filed by the applicant under Rule 11 of the NCLT. Order the respondent number 6 and 7 to submit facts of this tribunal for the FIR lodged against the respondent number 4 and justify that why the copies of resolution plan valuation report, COC minutes and other documents are required and how the police are concerned in the CRP matter, and if deemed fit, direct the erstwhile RP accordingly. First here see who is the applicant. Applicant is Sandeep Kumar Bhatt RP and he is the director. Now come to 6 and 7. Station House Officer, SHO, SSP, Raipur. The IBBI is empowered to investigate such companies. Now come to here. We have heard the parties and gone through the submission of the applicant. Section 233 of the IBC grant immunity. Everybody should remember, all friends should remember this provision. Section 233 of the IBC grants immunity to RP for action taken in good faith. Further, jurisdiction with respect to offences committed under the IBC is special court established in terms of Section 236 of the IBC. A proper procedure is laid down under the code for filing of complaint against the RP under Chapter 6 of the code dealing with inspection and investigation lays down the proper procedure to file complaint against the RP. Section 217 clearly provides that any person aggrieved by the function of the RP may file a complaint before the board. The IBBI is empowered to investigate such complaint. In the instant matter, the respondent number 1, 2, 3 failed to file any such complaint with the IBBI or even with this adjudicating authority and directly approached to the police. Here, the complainant, instead of filing complaint to the adjudicating authority or IBBI, he directly approached to the police. The NCLT Chennai bench in the matter of Subrata Monindranath Mehti versus so-and-so held as under. If there are any irregularities on the part of the RP or his team, the erstwhile could have filed necessary application before this tribunal and also could have registered complaint with the IBBI. No application has been before this tribunal for lawful discharge of the duty as RP, accelerating criminal charges and using police to register complaint of the criminal nature is not appropriate. If every judicial professional is bombarded with the criminal prosecution and police investigation, then no RP shall able to conduct CIRP without fear and favor. Since the entire allegations in FIR relates to CIRP under IBC by RP, this tribunal ought to protect the RP and his team. The RP is to take out necessary action to protect and safeguard, including quas FIR consent code. In the light of the above, we direct respondent number 6 and 7. 6 is the SHO, police, and SSP is not take any coercive action against the applicant, that is RP. Further, the respondent number 1 to 3 are directed to approach IBBI for any complaint against each electronic disposal file to be consigned records. So this is the case law which is very important for all RPs or IPs or liquidator, because one should know about the rights, what rights available to the RPs. RP is treated as a, or IP is treated as a officer of the court, number 1. For that, IBBI has also issued letter to all IPs that you are being treated as a officer of the court, number 1. Number 2, under section 233 of IBC, immunity has been granted to all IPs who has been performing the work of CIRP or liquidation in good faith. Now come to next. If anybody has any questions, please ask. Recent orders. Shall we take break for 5-10 minutes?
Yes, yes.
Okay, thank you. So again, we will join exact at 3:30. Okay, thank you.
Okay. Thank you, sir.
இல்ல டிஃபால்ட் இல்ல ம்
Once again, good afternoon, everybody. Now, shall we start?
Yes, please.
Thank you. Now, we will discuss the landmark judgment in the matter of SR Steel. You might have been aware about this judgment, but this judgment still applies in all cases, and that's why it is called landmark judgment. We should remember the fundamental or basic aspects of this judgment, this SR Steel. I'll share the judgment and we'll read the only head notes because this is running more than 100 pages. So nobody has time to read the entire judgment. We will read only head notes, and that too bullet points. Because IP is having lots of work. IP cannot read the entire judgment. IP should only focus on the head note, and then he can apply. Thereafter, he can take the legal consultancy of the council also. Sorry, see, CRP period has to be finished within 180 days, thereafter 90 days, and maximum, if litigations are going on, then 330 days, as per provisions of subsection 3 of section 12 of the code. Just a moment. What happened here? The matter came before the Honorable Supreme Court, and the matter was referred before to the Honorable Supreme Court for extending the CRP period beyond 330 days because of the litigation was pending. So here, the Supreme Court read this provision, the insolvency IBC, section 12, subsection 3, as amended by so-and-so, providing inter alia for mandatory completion of CIRP within a period of 330 days. Validity of amended section 12, subsection 3, affirmed in its entirety, except that the word mandatorily is struck down as being excessive, arbitrary, unreasonable restriction, being violative to Article 14 and 19(1)(g) of the Constitution of India. Here, what legislature has done here, Mr. I'll read this section 12(3). Section 12, subsection 3. On receipt of an application, under subsection 2, if AA is satisfied that the subject matter of the case is such that CIRP cannot be completed within 180 days, it may by order extend the duration of such process beyond 180 days by such further period as it think fit, but not exceeding 90 days, provided that any extension of the period of the CIRP under this section shall not be granted more than once, provided further that, now the proviso, provided further that the CIRP shall mandatorily be completed within a period of 330 days. See, here legislature has used the word CIRP process shall be completed was enough, but here legislature has added mandatorily. This word is anti-constitutional, unconstitutional, excessive, arbitrary, and this is violative to Article 14, what Supreme Court has observed. And this word should be struck down in the SRC still there. Because, let me explain about the fundamental aspects of the law. Law of the land is, first law is mother law. What is mother law? Mother law is the Constitution of India. All acts or any other law which is against the Constitution of India is non-est in the eyes of law. Any law which is unreasonable, arbitrary, excessive, or violative to section Article 14, 19 or other articles is non-est or non-operative. So same things has held by this Honorable Supreme Court in the case of SR Steel. Why this has been held? Now come to next para. Supreme Court held that the general rule is that of an outer limit 330 days. However, held extension of time can be granted in exceptional cases. Exceptional cases would be cases where only a short period is left for completion of insolvency resolution process beyond 330 days, and it would be in the interest of all stakeholders that CD be put back on its feet, and where the delay or large part of, or just a moment. Yes. Where the delay or large part thereof is attributable to the tardy process of the adjudicating authority, appellate tribunal itself. Further, where the grace period of 90 days from the date of commencement of the amending Act 2019 is exceeded, there again discretion can be exercised by AA or appellate tribunal. Further extend the time held, given the fact that the time taken in legal proceeding cannot possibly harm a litigant if the tribunal itself cannot take up the litigant's case within the requisite period of, for no fault of litigant, a provisions which mandatorily requires the CRP to extend by certain date without any exception thereof may well be excessive interference with the litigant's fundamental rights to non-arbitrary treatment under Article 14 of the Constitution, and excessive, arbitrary, and therefore unreasonable restriction on the litigation fundamental rights to carry on business under 19G. Here, what stand the Supreme Court has taken the stand that even the litigant has fundamental rights. His fundamental right cannot be taken away because CRP is going on or CRP period has been finished. So any law which is violative to fundamental rights is antithesis to rule of law. The rule of law is the supremacy of law, law of the land. Supremacy of law, law of the land is the Constitution of India. If any law violates the fundamental right, is antithesis to rule of law. So here the litigants, if some litigations are going on, with whether before adjudicating authority or in another court, if NCLT does not conclude the litigation within 330 days, then this period can further extend it beyond 330 days. So this analogy, this principle was applied by the Honorable Supreme Court. Just a moment. So this is the SR Steel judgment. You can also use, if you are handling CRP process, 330 days has been over, you can still apply for the extension of the CRP period. taking the stand of litigation pending. If you find that this litigation must be concluded first before completion, then adjudicating authority must decide or adjudicate the litigation. Now come to in another in the same judgment, there are another view has been taken for different aspects. Now the commercial wisdom of the COC, you must have read many judgments with respect to this. Here in this judgment, and this judgment has been followed in all judgments where the commercial wisdom has come into play. Commercial wisdom of the COC held that while adjudicating authority cannot interfere on the merits of the commercial decision taken by the COC, the limited judicial review available in the is to see that COC has taken into account the facts that the CD needs to keep going as a going concern during the IRP, insolvency resolution process, in order to maximize the value of the assets and in the interest of the all stakeholders, including OC. So this judgment has been applied in all cases, future cases also. Now come to relevant para. We have already read the head notes of this thing. Now time limit for completion, read 12:30. If any question you have, please ask. You can unmute yourself with respect to this judgment, because this is the landmark judgment of the Honorable Supreme Court in IBC. There are 5-6 important judgments, although all judgments having different significance, but like Mobilox, SR Steel, Ghanshyam Mishra, these are the judgments which have been following in all judgments and relying in NCLT and CLAT. So we should aware about these basic judgments. Now come to SRA. Now 138. Check issued prior to CRP period. 138 case was going on, and 138 was going on against the CD and director who has signed this check. But CD is immune under section 14 of the IBC. So 138 proceeding cannot be continued against the CD because of moratorium has been imposed by the NCLT and section 14 also. However, criminal proceedings under section 138 of the NI Act, negotiable instrument, will continue against the offender or against the director who has issued the check, who is the offender in this under section 138. So I'll read the just concluding part of this thing so that you can advise to your management also. Your management means suspended director. I'm sorry. Thus, the upshot of all this decision referred to above is where the proceeding under section 138 of NI Act had already commenced with the magistrate taking cognizance upon the complaint, and during the pendency, the company gets dissolved. The signatory director cannot escape from their penal liabilities under section 138 of the NI Act by citing its dissolution. Company got dissolved. Now they are taking the stand that company got dissolved, so I am not liable. So this is not the correct. Here, Honorable Supreme Court held that what is dissolved is the only company, not the person, not the personal liability, personal penal liability of the accused covered under section 140 and 141 of the Negotiable Instrument Act. I may draw my final conclusion as under: after passing the resolution plan under section 31 of the IBC by adjudicating authority, and in the light of the provisions of section 32A of the IBC, the criminal proceedings under 138 of NI Act will stand terminated only in relation to CD. So NI Act qua corporate debtor is the only area where the immunity has been granted to CD. If the same is taken over by the new management. Section 138 proceeding in relation to signatories oblique directors who are liable covered by the two provisions to section 32A subsection 1 will continue in accordance with the law. This section is of NI Act. In view of the above discussion, the appeal fails and hereby dismissed. Connected appeal also. So this appeal was filed by the suspended director against the order of magistrate for continuity of the proceedings against the suspended director. Any questions? Because you might have come across such kind of situation. Director must have approached you that some cases are going on. So you are not supposed to engage or advocate for this for protecting the for the purpose of this directors. You can engage advocate only for the purpose of CD and file order of the NCLT that CRP has been started or liquidation proceeding has been started. So please absolve or remove this CD from the area of parties. You should file an application through council for removal of the name of the CD from the array of parties. Is this clear? Otherwise, now this magistrate or district court has also aware about the implication of the insolvency bankruptcy code. Initial stage in 2017-18, nobody was knowing and nobody was relying on this order of NCLT. And this was happening in also electricity matter also. Electricity bill, due to pendency of the electricity bill, electricity company disconnected the power of the corporate debtor due to outstanding of the electricity bill. Now, this in the matter of Tata Power, I'll share this judgment, which is landmark judgment for Tata Power judgment. Just a moment. SR still decision plan for this guided by IBC. Noida Authority. This is different. This is different. Just a moment. I think it has been missed out. Nonetheless, I will just explain verbally what happened in Tata Power case. Tata Power case, the dues was huge, and this the Tata Power issued notice for disconnection of the power due to outstanding dues. The company was not having fund to repay the debts of the Tata Power. Then application was filed before the NCLT, and then the NCLT, sorry, I don't have order copy of NCLT, but order copy of Supreme Court is there. This matter went up to Supreme Court, and Supreme Court held that IBC overrides the other acts, local laws, electricity laws, and other laws. And dues of the Tata Power will be governed in accordance with the provisions of Section 53. If your dues gets paid under Section 53, you can receive the payment, but you cannot disconnect the power on the basis of outstanding. So this is the immunity granted to CDs or the new management. Sometimes this new management also asks to pay the dues. So he can take the plea, he can take the defense of Tata Power case, which has been held by the Supreme Court. Now I'll share recent orders. Recent orders. I have read 2-3 judgments of this thing. One judgment in which the liquidation initiated and thereafter NCLT allowed the CD to come out from the liquidation proceeding. But here NCLT Chennai bench held, once the liquidation proceeding starts, CD cannot come out from the liquidation process because there is no provisions contained in the code. Adjudicating authority held that liquidation process, CRP and liquidation process as of two separate stages, and the procedure to be followed in each stage have been delineated by way of framing a separate regulations by the regulator. There is no provisions under the IBC to come out of the liquidation process once the liquidation is ordered, except by way of scheme under section 230 of the Companies Act or by sale as a going concern. So 230 is the compromise arrangement, amalgamation merger. Okay. So in CRP process, there is a clear-cut provisions 12A that this or regulation 30 also, that IRP or RP shall file an application for withdrawal upon the request of the financial creditor or operational creditor for settlement due to settlement. But here, even settlement take place during liquidation? No. Once liquidation start, it will continue, subject to provisions of 230 and dissolution, whatever provisions applies here. Now come to another judgment. Interest on delayed payment. I'll stop here. I'll ask question. I'll put one question before you, and I'll request to participate in the discussion also. CD has supplied, operational creditor has supplied some material to CD, say worth of rupees 1 crore, and in the supplied this invoice, there is a terms. In case of delayed payment, 18% interest will be levied or will be charged from the CD. It has been written in the invoice, the basic terms and conditions. Okay. In back of the all invoices, you must have seen terms and conditions of the sale. Whether CD is liable to pay the interest or RP,
Yes.
or RP is obliged to admit the interest along with the principal amount of rupees 1 crore.
Not liable to pay unless the agreement of supply provides for the interest payment.
Okay.
No, sir, I am of the view that if it is mentioned in the invoice, then interest is payable, sir. And most of the RPs, they are accepting claim of the principal plus interest.
Invoice is not a contract.
No, but
Munishji, you are giving two different statements. One, first time you said yes, it is admissible. Another say
No.
Okay.
I said in case the terms of supply or agreement under which the supply is covered provides for interest, then it's admissible. If it does not provide, or in case there is no agreement under which the supply is being made, the mere mentioning on invoice does not make interest as admissible because it does not amount to a contract between the parties.
Okay. Any other views?
See that mentioning on the back of the invoice or at the bottom of the invoice, that amounts to a clause in the general clauses will be there. General clauses and terms subject to which purchase order or supply invoice is raised. So
Sir,
it becomes payable.
Sir, you are stressing on your mind more than required. We have already discussed. First rule of contract.
Privity.
At the beginning of the session, I first read section 10, section 13 of the Contract Act. I told you this will apply everywhere, whole life, in your personal matter, in your insolvency matter, everywhere. There must be privity. Here invoice has been issued by the seller. It's a one-way traffic. It's a one-way traffic. There is no bilateral contract. This purchaser or CD has not signed the invoice. It is a unilateral action of the supplier. But now come to, I'll read the judgment of order of this NCLT. There are two divergent judgment here. Very interesting. NCLT Hyderabad bench held a default occurred on the part of the CD, the absence of any pre-established convention for charging interest in cases of delayed payment became irrelevant when payment against the invoice were not received at all, and an acknowledged default of the principal amount happened. It is precisely at this juncture that the applicant invoked the clause specifying an 18% interest charge that was clearly stated on their invoice, which accompanied the supply of goods to the CD before the initiation of the CRP. Second, the interest claim of the applicant is undoubtedly the claim within the meaning of section 3(6) of a debt owed within the definition of under section 3 subsection 11 of the IBC. So this is the judgment or order of the NCLT Hyderabad. Now come to another judgment of Delhi bench. Merely citing the interest rate in the invoice by itself would not render it legally binding for the corporate debtor. Rohit and company operational creditor of the here. The NCLT bench Delhi 4 held with respect to the issue of claim filed by the operational creditor, it is observed that merely citing the interest rate in the invoice by itself would not render it legally binding for the CD, as the purchase order do not bear the signature of the CD anywhere. The RP has taken the conscious views by verification of claim, keeping in view the terms of the purchase orders and books of accounts of the CD, which only included the principal amount, and principal amount was duly admitted by the RP and was part of IM. Regarding the issue of not providing Form C of CST as requested by the applicant to the RP, it is observed that Form C relates to the period of 2013-15, which is before the commencement of CRP. The RP stated that despite his best efforts, he could not locate those documents. The applicant should have obtained Form C from erstwhile management of the corporate debtor during that time. So here Delhi NCLT has rightly held that merely writing on back of the invoice that in case of default, in case of non-payment of particular amount within particular period, given period, interest will carry at the rate 18% is not sufficient unless it is signed by the CD. So is this clear?
But when invoice is sent through mail, signature is it required? Because in the current day.
So by email, he should accept. Yes, I accept your terms and conditions. Show me the terms and conditions you have accepted. Yes, the supplier should ask this CD to please accept this invoice and terms and conditions. If CD accepted, then yes, it is binding to the CD.
And signature, whether it includes digital signature also?
Yes. Even email is also considered as signature. Now everything is happening this virtual or this electronic mode. So physical signature is not mandatory. Here NCLT has taken view physical signature, which is not mandatory as per the law now, because everything has been happening as per the cyber law, as per the Indian Evidence Act also. Email is also part of the evidence. So nobody can deny. Once the CD has accepted by email that yes, I accept the terms and condition of the invoice, this terms and condition is binding to the CD. Okay?
Okay.
Thank you. Now come to we have already discussed the judgment. Resolution plan. How many of you are aware what the circular or guideline or letter, not circular, a letter issued by the IBBI to adjudicating authority or NCLT regarding appointment of liquidator? How many of you are aware? Because it is not reflecting in the IBBI website. It is not showing anywhere.
Yes, sir. It is showing only in the social media, sir. I am unable to locate this anywhere in the IBBI or NCLT website. And I am also of the opinion that the letter, so-called letter of the IBBA, goes against the code itself, IBC itself.
Okay. So you believe that this letter issued to NCLT is against the code and it's not binding. Am I right?
Yes, sir. And I doubt the veracity of the letter itself.
Okay. Anybody else can share their views? Please share your views. I'll share the letter.
Sir, this is merely advisory in nature, and again they're referring to their the powers which are prescribed in
Recommendation.
the
18th July letter issued by IBBI to all adjudicating authority. That recommendation
Yes.
for appointment of liquidator other than IRP. Code indices so and so time bound, and board recommends the
Sir,
replacement.
am I audible, sir?
Pardon?
Am I audible, sir?
Yes, please. Murthy ji,
Sir,
please.
this is more recommendatory in nature, but having so said, still they have referred to the powers they have to issue this letter.
Yes, you are right. Now I'll just reading this main points and main this para of this letter only for our knowledge, because we should know you are RP and many persons are RP. One must be aware before passing the resolution for liquidation that this is the position at present. Board recommend the replacement of so and so. Section 34 4B inter alia provides that AA shall replace RP if board recommends the replacement for reasons to be recorded during the review of performance of process of the code. It has been found that there is meager 4% average realization against the admitted so and so. IBC introduced the larger recommendation. Now come to last concluding part. The code envisages CRP and liquidation as two distinct processes with distinct role and responsibility. Thus, an IP undertakes the two different assignments as RP and liquidator separately. Segregating the dual role of an IP and in the same CD as RP and liquidator will foster an inbuilt system of check and balance in the process, thereby enhancing the accountability of each job and strengthening stakeholders' trust in the process under the code. Further, it would eliminate any perverse incentives, whatever available with the RP, in deliberately pushing the CD towards liquidation and secure next assignment on ex ante basis. In view of the above justification, the board in exercise of its power conferred under section 34 subsection 4 clause B recommends that an IP other than the RP oblique IRP may be appointed as liquidator in all cases where liquidator order is to be passed henceforth. Liquidation order, it should be liquidation order is to be passed henceforth. The liquidator can be appointed from the panel list of IBBI. I think you might be aware about two sections. One subsection 1 of section 34, which says that RP shall be appointed by the RP shall be the liquidator in case of liquidation proceeding if he has given the consent. If RP has given the consent to act as a liquidator, then he will be automatic appointed by the he will be automatic become liquidator even if adjudicating authority doesn't pass the order that Mr. So and so is appointed as liquidator. Still, RP shall become the liquidator, automatic liquidator by virtue of section 34. Am I right? If there is any contradictory view, please share. I will read then the relevant section.
Yes,
Section,
even after taking consent of RP, they are replacing now RP with the empaneled, RPs or IPEs to act. It has happened in one of the case very recently.
yes. So here, I'll share first provision that will clear it. Just a moment. I'll share the relevant provisions. Section 34. This is very important for all IPs because all IPs are putting lots of efforts for getting the resolution plan or for CRP work. But if it doesn't, if resolution plan does not get approved by the COC, then what happens? Come to 34 1A. 34 1A, sorry. 33 34. 34. Appointment of liquidator and fees to be paid to the liquidator. Where adjudicating authority passes an order for liquidation of the CD under section 33, the RP appointed for the CIRP under chapter 2. For pre-peg, I am not reading, I am just reading the relevant. Shall, subject to submission of written consent by the resolution professional to AA in specified form, shall act as a liquidator for the purpose of liquidation unless replaced by the AA under subsection 4. So here appointment of RP as liquidator is automatic. No prayer, no application, separate application is required here. NCLT will appoint RP as liquidator automatic, without prayer, without application. If consent has been given by the RP. Now come to subsection 4. AA shall by order replace the RP if resolution plan submitted by the RP under section 30 was rejected for failure to meet the requirement mentioned in subsection 2, or the board means IBBI recommends the replacement of resolution professional to AA for the reasons to be recorded in writing. So if board has recommended that no, in this particular case RP should be replaced, then RP shall be replaced by the AA with the reason. So he must give the reason also. Third stage, RP fails to submit written consent. So only 3 stages where RP cannot be appointed by the liquidator, cannot be appointed as liquidator by the AA. Now, IBBI has gone beyond this provision and has recommended to AA to appoint in all cases this liquidators other than the RP or IRP. Appoint another IP as a liquidator other than IRP or RP. So this is the recommendation. However, AA is accepting as a mandatory and is adopting or applying in all orders. Where liquidation order has been passed, you will find that AA is appointing somebody else. Now, here the analogy or this concept has been taken by the board that the other RP or IP will take care better. He will take care better than the appointed IP or RP. What is the guarantee that the another IP will act better than the IRP or RP if he is not experienced person and he has been appointed from the panel? IBBI has also suggested that he will be appointed from the panel of the IBBI, and in panel many persons are inexperienced, many persons are very experienced. If inexperienced person is appointed as liquidator in a big case or even a medium case, what will be the fate of the matter? What will be the fate of the liquidation proceeding? So this has to be reconsidered. I think there should be some also rider given by the IBB. We are just discussing this out of the box, but in every order we are discussing the anatomy of case law. In case law, you will find in recent cases IRP or RP has been replaced by the new IP as a liquidator by virtue of these guidelines or recommendation. See, IBC overrides all other laws. Further, IBC cannot be override by the regulations or the advisory, but AA is adopting this as a mandatory. I'll request to participant to share their views in this regard.
I think the section is clear, sir. I think the IBBA has to recommend case by case for replacement of the RP as the liquidator, whereas IBBA has taken a blanket power to suggest total replacement. I think the section is very clear.
Yes. Thank you. So I think it should be on case-to-case basis. Let's see. Law is still evolving. IBC is still evolving. So we hope that another circular will come after some time if something goes against the stakeholders.
I don't know why this circular was never circulated among the IPs, being the affected parties. This must have been
Yes.
circulated or must have been put on the website of the either NCLT or IBBA. I never received this circular. Maybe I missed out or something. I received it in only social media.
Yes, yes.
Not a circular, sir, just a letter.
It's a letter to advisory letter to
Yes.
AA, secretary to AA.
Because being the persons impacted by that letter, all IPs must also have been given notice of that letter, sir. That's what I feel.
Yes.
Sir, you could
You are
download it from the IBB website, sir.
No, it has been come through social media. He is right. Mr. Adi Narayana is right that it has come through social media. Also, it has come to me through social media only, not officially.
No, but this is not the one, sir. What you showed is not the one. The signed letter आया था official social media में.
This is I have received from different source.
Okay.
And
This is
surprisingly, this letter has come from a person who is not IP. Number one, he was attending one session about the career in IPs, and in that session, this letter was shared by the presenter, by the faculty, that this is happening here or this is the new development. So affecting party is IP. Suppose liquidation order has been reserved. IP or IRP has mentally has prepared. Even COC passed the resolution for appointing this IRP or RP as a liquidator. Adjudicating authority will not accept. So this should not come as a shocking news or surprise to the RP or IRP that he is no more liquidator. He is not associated with the CD from the date of liquidation order because AA has appointed somebody else as a liquidator in pursuance to the advisory letter of the IBBI. So I think everybody should know. That's why I have shared here. I have shared this letter so that you should aware that it should not come as a surprise or shocking news if liquidation order has been passed by the AA. Any questions? on the judgments which we have shared, which we have discussed. I think we have discussed about 15, 16 judgments till now.
On the letter itself, the last line says that the liquidator may be appointed from the panel list of IBBI. So it is not that the COC or the lenders suggesting the name of the liquidator. That is not mentioned here. It's simply
Yes,
saying that panel
from the
से जो है
panel.
उनसे
See
लेने के
what?
लिए बोल रहा है.
Suppose one company, suppose any company, like if you take like a name of the any big company or medium company, listed company, any ABC Limited, listed company having turnover of rupees 1,000 crore is a going concern. However, due to certain reasons, it goes into liquidation, and AA appoint a person from the panel of the IBBI who has not handled single assignment as a RP, IRP or liquidator. Now you can imagine the outcome of the work or fate of the liquidation proceedings of the CD without experience.
But not only that, sir. See, your name in that panel will be there only for 6 months because you are aware 6 months में एक बार IBBI gives a list.
Yeah.
Every time you can't apply.
But
AFA should be valid for 6 months.
in all this panel list, you will find many IPs are not experienced person. Because
Yes.
every day new IPs are getting enrolled with the IBBI. And liquidation is the second stage.
But later on, SCC can change the liquidator, no?
You are right. SCC still holds the fort, still holds the board. He can change under regulation, and in the SCC meeting, this liquidator can be replaced by the SCC. So this will again delay the liquidation proceedings. Suppose one liquidator is appointed from the panel, and after 60 days, within 7 days, SCC meeting held, and after 60 days, this SCC replace the existing liquidator by new IPs. Then 60 days gone, the whole process he will start from the beginning. So this will also waste the time of the liquidation process. In my view, see, there may be different views of others, but it is my personal views only. Any other views on this letter, or any other views on the judgments which we have shared, which we have discussed?
Sir, one particular judgment of NCLT in which we discussed about the check issued prior to the ICD and having encashed after the ICD. What I was thinking that maybe the NCLT has grossly erred on that count, because it has relied on a case law that is applicable to the taxation matters. In the taxation matters, normally the date of the check presentation is the date of the tax payment. Otherwise, people will be put to hardship.
Sir, that the judgment has been applied by the Kolkata NCLT in his judgment, in its judgment.
Yes, sir.
Yes.
The judge.
So, see, NCLT order is not binding to another NCLT order. Kolkata NCLT order is not binding to other NCLT. It is binding to its. So, that's why I told all IPs must take precaution once such situation come that checks get encashed during CRP period, which has been issued prior to CRP period. We must apply to adjudicating authority for stay or for refunding the encashed amount.
Yes. Thank you.
Anjali ji, are you there here?
Ajay ji, I have a small question out of the context. In fact, we have not discussed this particular matter now until now, but this is a very interesting part wherein there was a corporate debtor which is gone under liquidation now, and it has taken an interim finance. It had, in fact. The COC had approved for the interim finance also. Now, what had happened is that the company is now into liquidation, and from the realization part, doesn't have money to repay to the interim finance. So, is there a way out, or can the COC be implemented in this, saying that there's no COC approved for this, or will they have to suffer the loss?
Srikanji, during
Ajay.
liquidation, there is no COC, number one. During liquidation, and there cannot be, there is no concept of interim finance. I haven't read any.
No. I understand that. Okay, probably maybe I would have said in a different way. The company went into the CRP process, and during the resolution plan, there was no resolution plan, in fact, but in between, they tried their best, and that is how this interim finance was arranged. And interim finance at that point in time was approved by the COC. Later on, 5-6 months down the line, they felt the company is not, the CD cannot be, brought back to operation, and so it has to go to liquidation. The CD went to liquidation. Now, as they have not paid a single penny as regards the interim finance is there, the liquidation cost, whatever is been recoverable at this moment in time, they do not have sufficient money for the interim finance either. So the interim financer came in between, and he got in trap.
So you are concerned with the what will be the fate of interim finance when he will get the repayment of interim finance?
Yeah, or there is a possibility that the COC can also be brought in to
there is order of payment here. Order of payment given in 53. Section 53 is given.
Yes, and as per that, this becomes part of the IRPC.
Yes.
Yes.
So it will be paid as per the 53, that is, it falls within the provisions of A, subsection 1, this clause A only.
Correct. So which means to say that whatever is there, that can be paid, otherwise not paid.
Yeah.
And the COC cannot be asked to bear the loss because they approved for the interim finance.
Yeah, if there is no fund, how can they pay? If there is no fund, the financer should have taken, should have considered, should have done due diligence before giving the fund.
Yeah, true. They should not believe on
he should have thought that why he should invest, he should put money for chasing the bad money. His good money should for chasing the bad. So
in fact, I believe this was also discussed in MCO case by the Honorable NCLAT Principal Bench.
Pardon?
I believe this was also partially discussed in MCO Limited case.
MCO?
By NCLAT and Principal. MCO, EMCO.
Okay.
There and also the final judgment decided by the NCLAT said that they cannot make the payment. In fact, because COC had not approved. In fact, here in this particular example which I gave, the COC had approved the interim finance, whereas in MCO's case, the interim finance itself was not approved.
Okay. So if this interim finance was not approved, then there was no fund inflow in the CD?
No, there was a fund inflow. That is how that has happened. That is not discussed in this particular case. How this RP said, no, this was in MCO's case, RP came out and said the company was operational. The company there was a chance that the company could be revived, but later on it could not be revived.
So it is violative to the code. Now RP has committed the violation of the provisions.
Exactly.
Yes.
From the order, from the judgment, when we read, we get a feeling that, but I do not know why the action was further not taken. It is not discussed.
Yes, it's violative to the code.
Thank you.
And thank you. Any other questions? Any other discussions? Because we have covered many judgments, and I would also like, Anjali ji, are you there? Ajay, I'll also like to brief about myself. Myself, Ajay Jain, advocate. You have seen my name here also. I am also yoga instructor. My profession is advocacy and passion is yoga and meditation. So I will suggest all IPs to take care of your health, devote at least 30 or 45 minutes for yourself. Your output will increase. If you are thinking, no, in the morning I will work for the CD or for I will do this thing, I will earn the money or I will my output will be more. My view, my personal experience says no, it's wrong. If you want to enhance your output, you increase your work level, your health should be very good. How your health will be good? Once you adopt yoga, meditation, pranayam in your lifestyle. If you adopt,
why not to hold a meditation session right now, 5-10 minutes?
sure, Anjali ji allows.
अंजलि जी बताइए.
हाँ, अभी कम से कम 10 मिनट का तो कर ही सकते हैं, ज्यादा भी नहीं तो.
हाँ, we have time.
It's okay, sir.
Last
We
one
can
is
go
the
on.
opportunity.
Okay.
Sir, may I ask a question? Slightly unrelated to what we discussed. Now, in one of my cases, NCLT rejected the resolution plan approved by the COC. Okay, the matter went to NCLAT, which ruled in favor of passing of the resolution plan. Right. Now, the aggrieved party, which
Naveen ji, your voice is cracking. You are not audible. Naveen ji, your voice is not audible.
Yeah. Should I repeat my question?
Yeah, please.
Yeah. See, in one of my cases, NCLT rejected the resolution plan, which was approved by the COC. Okay. Because it was challenged by one of the financial creditors.
Okay.
The matter went to NCLAT, which ruled in favor of passing of the resolution plan and remanded the matter back to NCLT. Right. Now the aggrieved party, which is the financial creditor, which had opposed the resolution plan, has gone to Supreme Court.
Okay.
Within the 45 days window available to him. In the meanwhile, can the NCLT approve the resolution plan? Because there's no stay order given by Supreme Court. In the interim period, can NCLT
It depends
approve
upon
the
NCLT. See, it depends upon NCLT whether NCLT proceeds with the matter or not. If NCLT finds that the matter is sub judice before the Honorable Supreme Court, it may wait for the order of the Supreme Court. And in most of the cases, as per my experience, I have seen the matter, if matter goes to the Supreme Court, NCLT do not pass any order and wait for the outcome of the Supreme Court.
But it's not binding on them. You know, they can
No,
still...
it's not binding. If there is no stay, no binding. But just they take precaution.
Yeah. Okay.
So what I was telling today, in today's session, we learned very fundamental aspects, which we have discussed initial. Privity. Wherever you enter into contract, wherever you find any difficulty, without consulting to any advocate or any person, first check parties to the contract, consent, name of the person, that's it. And then you can take another call. Then you take call on this agreement or the contract. In one of the case in which I came across one problem, the director, suspended director is the landowner, corporate debtor is the owner of the building. There is 2 acres of land in which one building was constructed, showroom was constructed by the CD, from the fund of the CD. Land belongs to suspended director, buildings belongs to CD, and that building was let out to third person. So suspended director is the owner, lessor becomes the CD, and this lessee was the showroom owner. Rent was going to this suspended director, which is against the terms of the agreement. So we have to see the locus. What is the locus of the CD in particular agreement? if rent should come in the account of the CD, then we must invoke that clause as per the lease agreement or as per the contract terms. Such situation will come whenever you handle CRP process, such situation will come. On the other hand, if land has been, if building has been constructed by the suspended director and it has been given to the CD on lease, in that case, CD cannot be treated as owner. Even if during CRP period, lease can continue, but CD will not be treated as owner. Or once the lease period terminates, the building will goes to the suspended director. So this is just practical situation which I have faced. I have come across through my client. So I was just sharing this thing. So shall we start 2-3